Greetings and salutations. Welcome back to another episode of the Legal Beagles. Our favorite radio investigative reporter from Chattanooga, David Tulis, is here. You can find him on davidtulis.substack.com and also at tntrafficticket.us for the Tulis report. And we will welcome you here, David. What's going on?
Well, Gary, I think it's very important that your listener have confidence in his skill or her skill in dealing with the officer on the stand in traffic stops. And we both agree that traffic stops are extremely important, not just so that we can learn how the enemy works against us, so that we can defeat them at the local level, knowing that there are legal fictions that control the courts of appeal and control trial courts where there's a jury. Those judges are trained against our line of thinking through the SOVSIT trainings that they get in their judicial conferences. These conferences effectively tell the judge that they can dismiss what we have to say, especially if there are legal buzzwords that SOVSIT type people or patriots or constitutionalists or want to use, and they can dismiss us without a hearing. So they can sort of rule and run, hoping we'll just forget it and just pay the fine. But our goal should be to have a proper legal defense and to know where our questions come from when we have the deputy or the trooper or the city officer or the cop on the stand. And so that's what I want to do, is try to encourage you, Gary, and you, the listener or viewer, to know that there are a whole set of questions that come from a basic idea.
And so, just to be clear for the audience, this is going to be for a municipal court hearing. For instance, if you get a traffic citation or something of that nature, and you're going in and you want to put the trooper on the stand and ask the questions, and this David is going to supply us with a basic script for what we're going to be using here, right?
That's right. Well, exactly right. Now, here. We mentioned, I'm glad you divided this out between courts of record and your municipal or county court. Now, they're called courts of convenience because they have a herd, cattle call type of approach, and it's all done en masse in great speed without a lot of law taking place. It's mostly a place where plea bargains take place. But you can have a genuine interrogation and a genuine examination of the witness and accuser in the city court or the county municipal court. In my state, in Tennessee, they're called general sessions. Again, these are courts in the criminal division that are without jury trial. They have criminal parts, and so you have the same standards that apply in a trial with a hearing in the sessions or JP, meaning Justice of the Peace Court, in your state. So those are courts of convenience, as they're called, where the goal is to get the cases moved out in a large number. But wherever you are, whether you're in the sessions court or Justice of the Peace Court or non-court of record in your county or state, whichever one you're in, the rules are the same. The other side has to produce 100% of the evidence. You're under no obligation to prove anything. And so you have to realize that means that my weapon has to be here. And also, if we go to trial, the weapon has to be the proper questions, and that's what we want to look at. What are the elements that officer is supposed to have here, right? And here, he's supposed to have seen certain things. What are those things? 100% of the evidence adduced against you is from his lips, okay, or his record, his form, his accusing instrument, which you should have a copy of. But I mean, there are all kinds of details we can look at, but what we want to look at, I think, is specifically the questions to sort of deconstruct his mind. Okay, what is he supposed to have in his mind? And you'll find inevitably in every state that the trooper, even the state trooper that's enforcing your state's transportation and trucking law, doesn't know what to look for, and they're all mistrained by the post-certified body, your authorizing body for certifications in your state. By policy, they mistrain or maltrain or don't train the officers, even the high-level troopers. Again, the troopers have the authority to enforce your administrative law, your transportation law. Your city cops certainly aren't going to have it, and your county deputies under the sheriff they're not going to have that knowledge either. So you knowing what they're supposed to have can be armed and confident when you go in, and that is essentially a script. So I propose that you do what I've done in cases involving family members and myself, and just studying of these issues. Have the script. What do you have to have uh, to know what to ask when you demand at that lower level to have the officer put on the stand? Because he is not just the witness; he's also the accuser. So there's a possibility if the district attorney or the solicitor representing the state in state versus your name, right? If that uh, officer or deputy is there without the solicitor being there, that he is actually practicing law. So that's a sidebar attack, a flank attack, you might say, on the state's case against you. Is the officer practicing law? Because he's not just a witness, he's also the moving party in that municipal court. And in the small towns, often the DA or the solicitor or the county attorney or city attorney is not there, and sometimes they don't even have criminal authority. So they're in a civil venue, which is city court. The municipal courts are civil only. I'd say that's invariably true in all the states. City court, the municipal corporation court, like I'm in Chattanooga, I'm in Saudi Daisy, next to Chattanooga. If it's a Saudi Daisy case, it has civil authority, and yet there's a quasi pretended, maybe usurped criminal jurisdictional authority that the case has moving against you in that city court, which again is civil. We have in Tennessee the famous case Chattanooga versus City of Chattanooga versus Davis, which makes it very clear that municipal courts are civil only; they can't prosecute crimes. And so that's just
well,
thing.
How are they processing traffic tickets then? Because that has to be criminal in
Well,
order for them to
yes,
stop you on the side of the road, because there has to be a witness of a quote unquote crime, right?
right. Well, that's right. Well, there's an unusual problem here, and I don't want to complexify what we want to get to, but
Okay.
traffic cases are administrative, Gary. Uh, I defeated a traffic charge against me in the county criminal court by pointing out that the case was premature for prosecution criminally, because under the presumed driver's license under which I was prosecuted, I had a right under our Administrative Procedures Act to have the case heard administratively in the agency charged in my state with driver's licenses, and that's called the Department of Safety. It's often called the DMV, but that's the state agency that oversees driver's licenses. So
Right.
these are truly uh, civil cases in the administrative realm, the state operating in equity, meaning as a business person, as a merchant, right? These are kind of merchant agreements between the people and the corporate body of the state, using your application equitably to have that driver's license. So in a way, these are civil cases, but they're all prosecuted criminally. And so since it is criminal, in a way, that's to your advantage if you think about it, because why? Why is it to your advantage, Gary, to be criminally prosecuted?
Because you can get a jury.
You get a jury, but what about the burden of proof standard? What about that?
Oh, it's a much higher burden
That's
of
right.
proof as well, too. Yeah.
That's right.
Sure.
Yeah, you have the higher burden of proof, so it's to your advantage, really, to be prosecuted criminally and not civilly. I know it sounds kind of backward. Better to be, better to not be criminal, but be civil. But if it's criminal, you have the security of knowing that the judge has to operate on the beyond a reasonable doubt standard, and also the jury if it goes to a jury trial. But can we get to the questions I think that I would want to recommend? And okay, so the first point to remember is the burden of proof is 100% on the moving party, which is the state. Okay, we're in a pretended criminal jurisdiction, and this is a criminal matter, and we're in the court of convenience where you're trying to get the case dismissed absent a jury. Okay, so effectively you're on trial. The judge is the finder of fact and the finder of law, and so you're trying to show him that this is let's say a nothing burger case. This is a kind of frivolous and trivial case that wastes the court's time and resources, and is against judicial economy, as you might say. So, Your Honor, we need to go ahead and dispose of this case. But I guess the question to get right into the question is, what are the elements of driving? And the officer, I assure you, doesn't know. He doesn't know what the essential elements are, but you do. And you want to give the short answer, Gary?
I don't have that on the top of my head here,
Okay,
here
the short
for
answer
Tennessee.
is, well, they're all the states are the same. The short answer in every case, as the legal beagles know, and all the gnomes know, and I here in Tennessee, I'm one of the gnomes, and I think in some ways I'm a senior gnome since I've been at this such a long time. But the gnomes are those who kind of mine the rich veins of liberty in the deep structure of the state, and that's what these cases are. These cases are kind of deep state operations, and we're not supposed to know how they operate, but we over the years we found out that driving, the essential elements of driving are commerce, and so it's important to know in your statute, which is in the transportation part of your law, it's probably under carriers. In Tennessee, your trucking laws are in carriers, which are utilities. Utilities will be your telecoms, your railroads, your dams, your waterways. Those are all in the utilities or the utility segment. So carriers in my state is one chapter. It's actually a pretty small chapter, about 30 pages. But there you'll find what constitutes commerce and driving. And driving and operating are commercial terms. They're terms of art. When grandma goes to visit her sickly friend at the nursing home, or when you take your children to with your husband or your wife to church on the Lord's Day, that's, you're not in commerce. You're moving or communicating or using liberty, constitutionally guaranteed liberties, to move your body and your chattel property from point A to point B. Right, that's outside of commerce. But commerce is what driving is all about. So driving has constituent elements, and you'll find in that motor vehicle code, again, specifically in the trucking part, right? You've got the whole book given over to the motor vehicle law in your state, like in mine, and the carrier statute is actually very narrow because it's federal, and the body of law for carriers probably is very narrow, and the larger body of law, as far as number of pages go, would be for the administrative part. Like I said, one volume, 2 inches thick in Tennessee on motor vehicles, and 30 pages on carriers. So carriers is the basis of the motor vehicle operation, which is made to apply to people who are not actually involved in hauling. So what is, to get to the point, let's just, since your listener probably needs to get out of your interview here and doesn't have a lot of time, but let me just tell you what the evidences are of commerce. And these are the questions that you want to ask the officer. Officer, what evidence do you have to testify to today that you saw in arresting and seizing me, that you saw cargo in my car? Did you see any cargo? And the question is framed with this prefix, deputy or officer, what evidence do you have to testify to today that? And that needs to be the formula. In my scripts, I'll have that as the main structure of the question, because in the end, his answer is, I don't have any evidence to testify to today, right? And the judge sees exactly what you're doing. The judge wants to hear what the evidence is of commerce. So the main question is, what evidence do you have to testify to today that you saw cargo in the front seat? Okay, so now you're breaking it down. Did you see cargo in the back seat? No. Did you see cargo on the roof of my vehicle or car? No. Did you see any kind of cargo strapped to the back bumper? No. What evidence do you have to testify to that I was carrying a trailer with cargo? No. So notice in those 5 points right there, just on cargo, just in the generic term of cargo, again, that's just the generic term. He has no evidence to testify to today that he saw those things. Okay, but it gets better, because there are details. When you break down cargo, cargo is evidenced by things that the officer should, if he's smart, right? If he's a trooper or a state police officer, he's going to be asking for these evidences of. What evidence do you have to testify to today, officer, that you saw that you requested a bill of lading? Because a bill of lading is the main document that a shipper has. If you're a driver, the reason you're driving and operating a motor vehicle is because you have, if not passengers, you have cargo with a bill of lading. And that's in my statute. My statute in the carrier section, that very slim part of the law, that's listed as the main thing that the trooper who has lawful authority to administer the motor vehicle carrier law under federal USC 49, he has that authority, and that's the bill of lading. So officer, what evidence do you have to testify to today that you saw a bill of lading? I don't have any evidence. What evidence do you have today that you asked to see the bill of lading? Okay, so notice you've got two questions on one detail of commerce. Officer, what evidence do you have to testify to today that you asked about logs regarding my trip on which you interrupted my travel? Well, he didn't see any logs. Logs are ELDs, which are electronic logging devices passed by Trump in 2016. They're also on paper. Those, again, are evidences of what?
Commerce.
What are they evidences of?
Commerce.
That's right. Driving and operating, right? You're being charged under the presumption of being in commerce. And so, deputy, what evidence do you have that you saw, that say laid eyes on a log, an ELD log? Okay, so you're asking about ELD. I don't have any evidence to testify to. Officer, what evidence do you have to testify to today that, going back again, that you saw the paper version of an ELD, of a LD, a logging device? What logs did you look at on paper? I didn't look at any logs on paper. What evidence do you have to testify to today that you asked? Notice we got three questions out of just the paper version. And again, each time the officer is going to say, I don't have any evidence to testify to that I asked about a log in writing with ink on paper. Didn't do it. Well, okay, now, and it keeps going. Notice what's happening here. The judge is seeing that there's no evidence. What about bills of waylading? Now, that's another kind of bill that's in my statute and maybe in yours. And you can ask the same question. Did you ask to see? Did you see? So that's two questions right now on bills of waylading, which is another type of evidence of that's right, operating and driving, right? If you're a driver, in fact, I just got off the phone with a friend of mine, Michael James, is a truck driver. I went over all of these things with him. I said, Mike, is there anything I'm missing when you are in your cab and you have to have these evidences because you're hauling cargo? And for example, another one is this. Now, Gary, this breaks down into several parts. Again, you want to, and listen, the judge is interested in your case.
Do you think it? I mean, do you think the judge is gonna admit that? Well, traffic tickets have to be based on commerce. Like, I mean, I haven't heard anybody ever say that. I mean, I know that's what the statutes say, but in reality,
Gary, now this is where your legal beagle has done her homework, okay, or his homework.
Okay.
And that is to say that you've looked up the cases that deal with these questions, and you do that by looking in your either at your university Westlaw portal, or just doing what you can find on general searches through Justia and other platforms. Maybe you subscribe or maybe free, but you're wanting to find out what these elements are, and you have a right to pursue your theory of the case. Your theory is that this is a case on privilege management. The privilege is the transportation privilege, the driving privilege, the operating privilege, and you have every right. I have every right, Your Honor, to plead the statute. I'm pleading the law in the statute, and I'm pleading the cases. So what I've done, and the one I could possibly republish, is in my daughter's Virginia case. I had, with all the questions, and she had this in front of her, the cases that specify how the breakdown occurs. So, for example, I hope we can have time to talk about reckless driving, but there too, you have the elements. Every charge has essential elements. They have to be named, and usually charging instruments are defective on that point. And you have a right to press the officer as to the essential elements, each one of which has its own essential elements. Okay, so you have these little parts of your inquiry, and you have a right to pursue your theory of the case, which is that I'm being charged with driving, Your Honor. I'm being charged with driving. I have a right to analyze what the parts are, and this officer has to prove the elements. He has to prove the essential elements of driving, which are commerce. And you're citing statute, and if you have had time to work on your case, which I trust by God's grace that you do, you found the cases that show exactly this, that all licensed activity is strictly for commercial purposes. So the one I want to get to next, if we have just a minute, Gary, is the manifest. What is a manifest? Well, a manifest has facts on the manifest. And you want to arrange your questions, again, upon the man on the stand who's sworn to tell the truth. Did you look at a manifest? Now, we know he didn't, because you were just on a shopping errand for milk and 2 items from your wife's list and some coffee. That was what you were doing. You were on private business or pursuing pleasure or necessities not involved in commerce. So the manifest is something he didn't ask about. So again, we're asking, what evidence do you have to testify to today that you saw a manifest that named a shipper on that manifest? This is called building the question. You are building the groundwork. You're laying the groundwork, and that's what good lawyers will do. That they don't just say, "Did you see a manifest?" No. Well, okay. You want to ask each part, but without giving it away, right? You want to frame it so that you get to ask all these questions, because the answer to each one of them is no. I do not have any evidence to testify to today that I saw a manifest that had a shipper named on it. Well, what's next? What evidence do you have to testify to today that you saw a manifest that had a receiver of cargo on that manifest? I did not see any manifest that had a line that had a receiver on it. You're going through the manifest now, line by line. You have a right to do that, because the evidence is that if you were involved in commerce, if you were driving, you would have these things with you. What about volume of cargo? Did you see a line on the manifest that had reference to the volume of cargo? What about the weight? Again, I got this from Mike James. What about, did you see a manifest that had a line giving a description of the cargo? No, I didn't see a manifest that had a line giving a description of the cargo. Did you see a manifest that had a description of the number of pieces that you evidently allege I was carrying? The number of pieces, okay, that's the number of boxes, or the number of units, the number of pallets, the number of crates, the numbers of bound or plastic wrapped boxes of some kind that a driver will have. Every driver will have these if he's involved in commerce. So right there, you've got 5 or 6 questions just on the manifest alone. And the manifest, again, has to be included as something he's supposed to ask for. If you're involved in commerce and he's accusing you of it, the cop, Gary, is accusing the listener and the viewer of being involved in driving and having a manifest, because that's what drivers do. They have manifests. But it gets even better. Gary, your legal beagle now is only done with part of her or his inquiry of this poor man on the stand who's never been asked this. He's never heard these things. He's never been asked these things. The judge is very interested at this point. The judge is intrigued. I mean, the judge, they don't get people like you very often. Give the judge something to talk about at dinner table tonight. And that's your questions, because you're asking the right questions. And where are you asking? Are these ideas coming from an overheated crank constitutional brainwave? No, these questions are coming from the book, from your code, and if you have time, by God's grace, and the cases. So, for example, the next area of inquiry is passengers. Okay, now you don't want to shoot your wad all at once. You want to build up the questions on passengers, because let me ask you a question, Gary. Is there a difference between an occupant and a passenger? Do you think your listener knows the difference?
Well, I would hope so.
Let's hope so. But okay, an occupant or a guest is someone. Let's say your daughter. she's not in her car seat anymore. She's actually sitting in the front seat when mom's not there. So your daughter's in the seat belt in the front right hand seat, and you're in the left seat, and your hands are on the wheel, and your right foot's on the gas pedal, and your left foot's kind of bobbing a bit there with nothing to do. But she, the daughter, is a guest. Now, if that daughter's paid you, that daughter becomes a different entity legally, okay? And the deputy's supposed to know this, your city cop's supposed to know this, your state trooper who has lawful authority and training to keep us safe on the roads is supposed to know this, but he doesn't know it either, okay? He doesn't know it. No one's ever asked him these questions.
I would be surprised if the judge knew this.
The judge doesn't know it because we haven't been informing our judges by asking proper questions. So the next area that you want to ask about the evidence of is the passengers. Okay, so you want to break it down seat by seat. Okay, you don't want to say, did you see anybody else in the car? That shoots your wad all at once. You want to say, officer, did you see anybody sitting in the right-hand front seat of my car? No, you're in a minivan, okay? So you've got 2 rows of seats, okay? You've got 3 seats in the mid row, and you've got 3 seats in the back row. So you have a right to ask him if you saw a person, a man or woman, boy or girl, in seat number 1, seat number, all the way through seat number, what would that be? 7, in the right rear of your minivan, okay? You have a right to build a question by question. You have a right to do that. And if the judge says, this is taking too long, you say, Your Honor, and you get firm, okay? You get firm because you know you're right and you know what the law says. Your Honor, I'm sorry, I have a right to ask my questions. This matter is being tried here, and I have a right to pursue this law. And Your Honor, I'm doing what good lawyers do. And I've watched some TV, Your Honor, and I know what good lawyers do. They plead the statute, and Your Honor, sir, Your Honor, judge, they plead the cases. And that's what I'm doing right now to this good officer who needs to know what the law is. And I'm here to tell him what the law is, because I'm asking what I'm finding out that he doesn't seem to know what it's about. And he has no evidence in this case. Sir, Your Honor, if you want to dismiss this case now, please do, or we can continue. Which do you want to do?
Nice.
Because I've got more questions, Your Honor, for the witness. I've got more questions, and I have a right to ask the questions.
Well, this is certainly an interesting take on going about it. Could it really be this simple?
Yes, it is this simple, because driving and operating are terms of art. They are legally loaded terms defined in your law. Now, your statute, like in my statute, in my state, the statute hems and haws. Sometimes it'll state very clearly that a driver is involved in carrying goods and people for hire. It's in there for sure at least once. But the law writers who are lawyers who draft the statutes for the legislature, they're all playing games, and the courts massage the material when they get it in their law commissions after it's passed by the legislature. So it's massaged by judges who transform the law to suit them, and we know it suits them to favor commercial government. But when you get to passengers, to get on with what I want to get out here, Gary, there too you have multiple questions. Officer, do you have any evidence that you? Okay, so he has no evidence to testify to that he saw anybody else in the car who was a passenger, or even there was no one who was there as a person, man or woman, boy or girl. Officer, did you ask anything? Did you obtain any evidence that the people in the car, let's say there was a person, had a reservation to be in that car as a passenger? No, I had no evidence to testify to that I obtained evidence that that person was there with a reservation. Officer, do you have any evidence to testify to that you asked about that person's payment log, a payment log for that person to be there as a paying passenger? Again, if you're a driver and you've got people in the car, he has to establish as a fact that there were bodies in the car, and then as a legal conclusion to help the court that they were paying people, right? Because a guest who pays is a passenger as a matter of law in every state. It's this way in every state. I know it is in Virginia and Tennessee. In fact, the Tennessee courts refer to the Virginia case, that the Wilder case, that brings up this distinction. And these are
sometimes they make the distinction passenger for hire or whatnot, but yes, yes,
right.
In all 50 states, they're going to be something along those lines.
So this is generic. This is generic material. It's not Tennessee specific. And then also, if you're a passenger and you're the driver, you have on your passenger list, Deputy, did you, what evidence do you have to testify to today that you obtained, that you laid eyes on a passenger list, okay? And what evidence do you have to testify to today that you put your hands on a digital passenger list by looking at a screen? Okay, none. What evidence do you have to testify to today that you saw a written on paper passenger list or printout? He doesn't have anything like that.
Yeah.
Okay. So now he didn't look at any passenger lists, which means that there were no passengers. The person in the car he saw was your daughter in the front seat. And officer, did you obtain any evidence today? What evidence do you have to testify to today that's the formula, right? That you saw, that you laid eyes on a passenger pickup and drop off report or log. Again, those are something that if you're involved in a commuter service or a bus service, carrying people, let's say from one major city to the other, you have, because they paid to be there, they pay by credit card usually, and there's a list that he checks off to note that everybody's arrived, so y'all can, so the vehicle can leave, right? It's a vehicle if it's involved in commerce. And so you've got right there, you could make it a dozen questions if you break it down, but notice what I'm doing. I'm breaking down the elements. And then at the end of that sequence on passengers, Gary, your legal beagle viewer can say, so what evidence do you have to testify to today, then in general, officer, that there were paying people in the car?
None. He's got none. And so, yeah, it's interesting to get him to start saying, I don't have any evidence. I don't have any evidence. I don't have any evidence.
That's right.
And so it's a pattern. And at some point, someone in the courtroom is going to go, well, what is this about? And I guess you have to tie it all in, but.
Yeah. And of course, as you go, you can, after each part of your script, you can ask the judge to dismiss because there's no evidence. But Your Honor, I'm happy to go on. I've got a couple more questions to ask, a few more questions to ask. And here now, Gary, it goes further. If you break down cargo, break down the boxes, and you're wanting to determine the nature and observability of the cargo, or these really are your personal effects in the car. Maybe you had some mail. You had a piece of mail come from your pickup at the post office, and there's a box in the back seat. So there's a box in the back seat that he sees. And it's brown, it's just a brown box, and it just the mailing labels happens to be aimed downward. But he sees it and he says, well, I did see a box in the back. Okay, so you ask him about that. And if it's cargo, what evidence do you have today to testify to today, officer, that you saw pallets, any kind of pallet in my car? Partial pallet, half pallet? Because cargo comes in pallets, okay? It comes in large crates. And it also comes in wooden boxes. So, wooden boxes can be big and small. You can have a small wooden box that might fit in the back seat of your subcompact, perhaps. Right? Did he see any wooden boxes that were potentially cargo? But you're not asking him to draw legal conclusions. The problem is that cops and deputies will often say things like, "Well, I saw you driving." Well, no, and if a cop makes a statement like that that draws a legal conclusion, you have to be very careful to object. And you want the judge to say, Your Honor, could you tell the witness not to make statements of legal conclusion? He's here as a fact witness, and he can only testify to facts. He can't testify as to whether I'm driving or not. All he can do is testify to is that you were moving. Okay, you were moving. You were in a red car, which is let's say a Ford, a Ford SUV perhaps, or a minivan or something like that. But you want to break down how is it that cargo might appear. It could be frozen. It could be commodities. It could be there could be evidence on an app on a phone, visible on a screen. It could be evidenced by a paper document. So what we've done, we sort of deconstructed his job, which he's supposed to do. Now, can I? I know your time is limited, Gary. I wanted to get to another thing, which is doing the same thing on a charge that has some elements.
Yeah, I mean,
Can we
the
talk
only
about
thing I would say
Yeah.
about the wooden crates is, if you're a baker per se, and you're transporting a bunch of cakes or pies or something to go sell, then that would be, not in a box necessarily, but as cargo. But I take your point. The question I would have you used this line of questioning on any officers yet?
Yes, my daughter Abigail was falsely accused on Highway 81 going through Virginia, a notorious bit of federal jurisdiction, by a state trooper who lied on the stand, and she was convicted of driving too slow. She was convicted of driving recklessly because she was driving too slow, which endangers people who are driving too fast, the judge determined. And Virginia is a criminal organization, and its courts are criminal, but we developed a very powerful script that she actually used. And I've used these concepts on other people reporting on their situations, and also trying to analyze how can this poor victim of police power free himself in the court, in the the gateway court, the city court, or in my state the sessions court. How do you do that?
Right.
And so I've developed these scripts, which are the basis in every state, the same kind of thing. Eddie Craig has done something similar, but not quite in this fashion. But what we're trying to do is show that there's no evidence. But let's say my daughter's charge was reckless driving. Her name is Abigail, an artist, and her charge was reckless driving in Virginia. And what she did was, I helped her break down all the elements of that charge, and there are 6 elements, all told. And let me just read you the Virginia statute. And it says, irrespective, this is at 46-2852 in Virginia, the Virginia Driving Code, or Virginia Code annotated. It says, irrespective of maximum speeds permitted by law, any person who drives a vehicle on any highway recklessly or at a speed or in a manner so as to endanger the life, limb, or property of another person, of any person, shall be guilty of reckless driving. So it's one sentence, but it has 3 very clear elements. I would say there are 5, and if you put in transportation questions on right to travel, that would be 6. But she and I decided that we wouldn't try to bring up the fact that she was just, moving. She was communicating by car, traveling by car. We decided not to bring that in to sort of simplify the proceedings. But you'll notice that conditions are part of the charge. That would be irrespective of maximum speeds permitted by law, and that implies conditions. Conditions matter. So part of her questioning was on the conditions of the road at the time of the encounter. And then there's also mens rea, which of course means guilty mind, which is intent, and that would be recklessly. Okay, recklessly implies careless disregard of other people. Okay, now if there's intent, there has to be another element that's kind of pulled in, and that is the presence of other people. So another part of her inquiry was about the presence of other people. And that we broke that down into a whole bunch of questions for the trooper who never, he was so aggravated and so perplexed at what was going on. It had never happened to him before that he, when the trial was over, it was an hour-long district court trial in Smith County, Virginia. He was so angry and befuddled that he was complaining to another person outside the court down at in the main lobby that he had just been dealing with a Nazi. And my daughter was coming around the corner, and she's a kind of woke, very modern young woman. She heard this accusation. She came around the corner, saw that it was him talking to someone else, and she had heard him say that. She had a kind of mental breakdown. Poor sweet girl of my daughter. But anyway, there was a whole other proceeding that followed that, a kind of controversy. But she had done the right thing.
So when she finishes this line of questioning with the officer in court, did she ask the judge to dismiss this? What occurred here?
Well, she did, but I think as opposed to the dealings of her case, I think what's important to realize is how you break things down. And a good trial lawyer will do this, right? The lawyers you pay $600 an hour for, this is what they do. Okay, they know that this is how it works, and so they deconstruct every part. The statute, they deconstruct it. They chart it on the wall. Okay, and that's what you're going to have to do. And I want you to think this is important. You say, well, this is just a traffic case. It's only $100, or it's only in my state. What were you saying?
I'll say it might be $400 or $500 over here in Western Louisiana, but sure.
Right. Well, you have to. These things have to be important, no matter what the dollar amount is. Okay. The reason these cases are not properly challenged is because of the low pain threshold they invoke on the populace. The populace is willing to accept this, and so 70% of the people just plead and pay without challenging. But if we want to ever be free, we have to challenge, and we have to know how to challenge. And that's what I'm doing. And my name, of course, is David Tulis, and you can find me at davidtulis.substack.com, and it's Tulis with one L. And that is what we deal with these questions a lot. And I've got a lot of material. It's not well organized, I'm afraid, but let's just quickly look at the conditions part of her questions. And that would be, okay, now taking into account conditions. Okay, conditions, in other words, you can be driving recklessly when you're driving 20 miles an hour on the interstate. And that's because there's ice on the road. And so if there's ice, driving 20 is reckless. Okay, so recklessness depends on conditions. So you see what I'm saying? Right. Conditions matter. And so, and your case law will have details on traffic cases, and there's a body of law that deals with conditions. Okay, so for example, do you have evidence that you can testify to that there was much traffic on the road? Okay, and the citation that she has in her notes, the citation is Spencer versus City of Norfolk. Conditions are an essential element. So conditions control reckless driving. If she's doing the speed limit at 65, then that is a condition that allows for 65 to be proper. Okay, it could be illegal if there's ice, if there's snow, if there's a crowd. 65 is illegal. Okay, that's reckless. So your questions have to ask the conditions in detail. Let me just break down a couple. This one element. Okay,
sure.
Like we said, there are 5 elements in reckless driving, 6 if you count the right to travel, but 5 main ones. Where there are pedestrians nearby. Okay, if there are pedestrians on this interstate 81, which there weren't, but the question again is, what evidence do you have today to testify to that there were pedestrians near or on the road? That's one question. Do you have evidence you can testify to today that anyone's property was alongside the road? Okay, we're talking again about pedestrians and people who have stuff. Maybe someone's hauling a wagon, maybe someone's hauling a wheelbarrow, maybe someone's rolling a tire because they had a flat and they're rolling the tire down the side of the highway. Okay,
sure.
Right?
Yeah, you
Someone's
gotta
out
ask.
of
Yeah,
gas,
yeah.
right?
What was there ice on the road? Was it raining? Was it hot? Was it
Right,
cold? Was it
right. Was
all
there
these
somebody?
questions?
Was there again the pedestrian angle could have several? Was there someone going down the side of the road carrying an empty gas tank, rolling a tire, carrying groceries? I mean, people in rural areas sometimes
True.
have to cross the road. Okay, so again, that's 5 or 6 questions right there, and you have a right to ask about conditions, and that right there is a condition. That's people. Those are proximate people in proximity, because reckless driving has to have people around for there to be recklessness upon. Right?
Right.
It's reckless. It's not reckless if there's no one around. If no one's around and there's only a trooper behind you, it can't be reckless by definition because no one's there to be threatened. The essential element has to be it has the act, the careless and negligent act of reckless driving has an effect on other people. The man with an empty jerry can, the man rolling the tire down because he's taking it to get fixed because he had a flat up ahead. Okay, that again, that's what we're dealing with. Was there anyone's property nearby? Can you testify that you passed anybody who had pulled over and was changing a tire? Right? Someone did we pass anybody who was on the side of the road who had the hood up? Okay, that's one question. Who had children and family on the side of the road while that person was changing a tire? Again, if you're going 65 in icy conditions and you're passing those people at 65, that's reckless, okay? But you have to determine as a fact, Gary, and the legal beagle, that's you. You have to determine as a fact that there were those people there. So notice what we're doing here. We're generating questions for which the officer does not have any evidence. Again, he doesn't have any evidence, and that he didn't that you with the cop behind you didn't pass anybody on the side of the road. So again, that is conditions, and that's also approximation of other people. And then, so was it raining that day? Were the roads wet? Okay, again, those determine. And if he has no evidence of rain, well, there you go. One more question for which there's no evidence. Were the roads? Was it windy? Was there wind buffeting your use of your cruiser that day, officer? Yes or no? No, I don't have any evidence to testify to that there was wind. Was there any lightning that night or that day? No, there was no lightning. Were there street lights overhead? That if it was night, that's a relevant question. Okay.
Hmm.
Were there lights ahead of us, officer? Red tail lights of people in front of us. Again, that's a condition. That's proximity of other people. Officer, was there lighting behind you? Were there cars behind you, officer, as you were trailing me? Again, if there were, uh, again, if it's an empty road, these are all questions to show there was no one around. And again, if it's reckless driving, it's important to establish that there was no one in front of you with red lights. There was no one behind you with beams or headlights. Again, all questions that are breaking down the parts of recklessness. Again, you're doing the same thing that you did with driving and operating. You're breaking down the facts. And again, he can only testify to facts. He can't testify. He can't say you were recklessly driving. All he can do is say what you were doing to make up the constituent elements
Yeah.
of reckless driving.
Yeah, so this is an interesting little layer. I mean, obviously we talk about all the time, filing your motion to dismiss, defining driving, and things of that nature, which could be in the court records for the judge to know why you're going down this line of questioning, and you spell all that out in your motions ahead of time. You ask the judge, did you read my paperwork? Well, yeah, of course I did. Ask him a question, see if he really did. He probably did not. But yeah, and then you go down these, and then you say, well, this is why this motion to dismiss is in, and that you need to grant it.
Well, okay, but you don't have when you file that motion to dismiss, it has to be purely a matter of law. Okay, now we're not dealing with law. Now we're dealing with facts.
Right.
The motion to dismiss deals with the legal improprieties or insufficiencies of the charging instrument. Usually, okay, there is purely a matter of law. But now you're getting into facts. And you have the only fact witness in your case, which is the officer. So what you want to do, of course, is try to defeat the case as a matter of law.
That's correct.
You're absolutely right. You're not going to win on the facts. You're not. You're not going to win on facts. You simply won't. He will lie his way out of it. Okay, he will. But what you're doing, if you're taking this tack, and you probably in your state, if you have that officer on the stand and the judge rules against you in this court, you have probably right to a trial de novo, which means a trial in a court of record, and you have probably 10 days to appeal it. So watch your deadlines. You have 10 days to appeal it, and this is not an appeal of record. There's no record made in this court. Okay. De novo means it's not based on a record. It's based on the facts presented new, the arguments presented new in the criminal court of record where you have a right to a jury trial. So I would say always appeal. If you want to try to, for practice, have your matter heard in the court not of record, the city court or the county court, for practice, so you'll know what's going on. And I strongly encourage you to do that. It's fun. You're learning something. You're maybe teaching these people something, and the judge is going to find you very interesting because you are very respectful, very respectful. You're honored to be there. You're honored to have the judge's time and attention. You're glad that you have this judge here. And Your Honor, I respectfully ask you to please give me time to continue, because I do have my rights to ask the evidence. These people have all the burden of proof, and since we're talking about a large number, 100, as in 100%, that means, Your Honor, that there may be 100 parts to what they have to prove. And I mean, I'm only on 40 right now. So, 100% means 100. That's a big number, and I might need a little bit of the court's time and forgiveness, but I have a right to ask these questions. And Your Honor, let's be honest. Most people don't know what to ask, but I've been thinking about your court. I've been praying about your court. I've been realizing you've got a very important job, and everybody seems to be letting these officers go. And I'm here to provide a public service, Your Honor, to the court and to the audience, providing a public service of asking these questions, because these are the things the officer, to get to 100, Your Honor, he needs to ask these questions. And these officers, Your Honor, I think maybe are not doing their jobs.
So no. Well, our idea of public service and theirs are two different things, but yes, but yeah, it's definitely another quiver in the arrow, another arrow in the quiver that you can go after the cop, and if they're going to railroad you, they're going to railroad you anyway, and but at least you can prove via facts that they don't have them.
Well, I'll tell you what, since I don't know what your time limit is, let me just say this: I will publish on Substack the word nincompoop, and the article, I'll have some material under nincompoop. Just look it up if you don't know how to spell it, and you'll find it on Substack. That's davidtulis.substack. And since you may be hearing this much later from the time I post the article, you can find it by searching for that word, and we'll have the Abigail transcript, or her script, and some other material. But again, it's so you can deconstruct, you might say reverse engineer his job. He doesn't do his job, but you can do it for him by reverse engineering it. And that is to say, knowing what he has to prove. Right. He has to prove 100% of the charge of driving and operating. And then when it comes to the specific charge of reckless driving, and there are other charges, but you can do the same. You can deconstruct those charges. And speeding, you can be accused of speeding and not be accused of reckless driving. You can be drunk and not be convicted of reckless driving. And drunkenness is not an essential element. So you can be drunk and escape a reckless driving charge by properly asking and knowing the law. And if you have the law in your script, you can immediately refer to it and say, Your Honor, this is according to, for example, on drunkenness. In Virginia, there's a case called Spencer versus City of Norfolk, 271 VA 460, that says that speeding is not necessarily driving recklessly. And there's another one dealing with, hang on a second. Well, just backing up on complete control. Do you have to have complete control of your car at all time? The answer is no. And so weaving, which might imply not control, but there are whole questions you can ask about moving the car, making adjustments in the lane. Recklessly implies serious weaving back and forth, jerking, violent movements, but there are all kinds of questions to ask as part of that category of deviations, slight movements within the lane, even touching the tire even touching the white line. That's not reckless. Okay, and there are cases in your state that show that. And for example, in Virginia, there's the case is Gale v. Wilbur. The law does not impose the duty upon a driver to keep his automobile under complete control at all times, because there are moments when you're not in control, like you're opening the glove box, or you're changing your radio signal, or you're changing, you're answering a call or something like that. So there's a slight movement and you're not in 100% control, but you don't have to be. Okay, so those are defenses, and you can ask 2 or 3 questions about that one fact of, well, you were weaving in the line. Well, slight movements, variations are not necessarily reckless, and you can show that pressing the officer, building the questions to have the judge realize there's no evidence that he has to testify to that you were doing anything that brings you into the scope of the law. Now, in a nutshell, before I let you go, Gary, is this: the facts. You're not going to win on the facts. Okay, so this is again for practice, and so you know how to argue the case. But you can, if you want to appeal this, you can then present your arguments on the law and the facts by argument. But his job is to bring you by facts into the ultimate fact of the law. So again, here's the idea: the officer's job, or the state's job, is to bring you within the scope of the statute. So by bringing you in terms of the facts alleged, so that those facts bring you within the scope of the ultimate fact, which is the law. Okay, the law is the ultimate fact, and he's bringing you by these lesser facts to the law. And if he can show that you're within the law, with the ultimate fact, with your facts, he's got a conviction, and you've lost.
Yeah, I think you've taught us an important lesson today. Don't go into court and ask broad, sweeping questions. You need to be very specific, bring it down to a very minute detail level, and just slowly, like you said, get that element and just slowly ask the questions leading up to the crescendo, which is, oh, you don't have any real evidence that I was driving, or I don't have, or whatever the charge may be. But this is definitely something that we haven't talked about yet, and it's something I think that needs to be. And I appreciate you bringing on the script and telling us that. That was very interesting. Thank you.
Well, again, the key word, Gary, thank you for having me. The key word is nincompoop. Just go to my Substack. Yeah. It's David Tulis, the one out, davidtulis.substack.com, and just type the word in on the window, and you'll find the Abigail Tulis script. And this is out of Virginia, and you can see kind of what she did. She's a young artist, and she did the right thing. She handled herself very well. I was hugely proud. A homeschool girl, one of 4 children, who took a mock trial as a homeschool student in high school, but she learned her lesson well, and the court had not had anybody like her, and probably hasn't had anyone like her since. And so there's a whole story about her. But this is what we did, using the law itself in your defense. So that's the lesson. I think that if we get the main idea, Gary, we can confidently go into court.
Yeah, I just hearing the officer was all upset and a tizzy outside the courtroom was good enough for me. But
he eventually got fired. He got fired.
Did he? Okay, yeah. Wow.
Doing the same stunts. I mean, he perjured himself, but he got fired for other tomfoolery.
Wow. Well, David, thank you for enlightening us on this topic, and I will put your little thing at the bottom. I'll put your Substack address at the bottom of the screen throughout the video, so people will be able to find it really easily.
Listen,
but I'll give you the last word.
I'm honored to have been here, Gary, and thank you so much for your interest in this. That you give time to Gary, that you give time to this, and that you legal beagles give time to these kinds of questions. I would say is very, very encouraging, and I'm so glad that you've paid a few minutes time, attention. Tell a friend about Gary. Tell a friend about Legal Beagles. You owe it to him to support what he's doing, get people to pay attention, And you're going to have to give some time to this. Okay, you're going to have to get some time, and by these means, we will, in God's good providence, free ourselves from commercial government, and we can win locally, but with continuing dismissals. That's what all we need. We need continuing dismissals.
Yep, and that'll take care of it in itself. Thank you. Have a great weekend, David.
Gary, thank you again. God keep you, sir. Thank you.